We're on.
All right. Hi, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for June 17th of 2024. Brad, we got a good week here. Go ahead, take us
We
away.
do. I'm hoping not to lose you. I don't know what it's like there, but with this heat dome and everything, the wildfires have been crazy, and hopefully you don't have to run out to one, but I know that's ever-present fear at the moment.
Yeah.
Um, let's go
Well,
to
I'm out
speaking
in
of wild.
Columbus, so I won't have
Oh, you're
to
not going out
I
to
won't have
anything.
to leave. Yeah, so
Okay. So let's go to San Francisco. And this is insane for so many reasons, but and this is a continuation of other things the same
we've
story we
we've covered it.
reported
Yeah.
on. We
Yeah.
have a firefighter who in 22 was, I think, at the firehouse,
No, he was
another
home.
firefighter.
He was home.
Um, what's that?
He was home.
Oh,
This
okay.
assault, this assault took place at his house.
Oh, it's not okay. Which brings the assault more interesting. So we've got this. Let's call it the assailant, the firefighter who beat this other firefighter up with a large brass spanner, right? A spanner wrench. And we all know on the show what the spanner wrench is, used to, adjust fittings, hydrant connections,
Yeah,
or truck
this
connections.
one is. I talked to a chief in San Francisco who was explaining it's more like what we call a hydrant wrench.
Okay, so kind
So
of
it's a
a
little bit heavier
big
than
C-frame.
your typical spanner is one thing, but this was they call it a hydrant spanner, but it's brass. It's pretty weighty, and
Which
he tuned this kid up.
Yeah,
Yeah,
he broke his arm allegedly, gave him a concussion allegedly, a lot of bruises and contusions. And yet it was broken up by a neighbor, I guess by the house, with a handgun who stepped in. We'll relate this to another similar case we reported on last week, but in any event, apparently the assailant was upset because he thought other people were talking about him. So he goes to the firehouse. The assailant gets the employee's home address, which they give him, maybe because he's another firefighter. I don't know. So he goes to the home with the spanner and then literally beats the living, blank out of him. So the suit names not only, the assailant, but also the fire chief, other chiefs, and company officers. This reminds me of the case we reported on last week, I think, where the city settles a case for 2.3 million because a firefighter shoots a co-worker, and they said you should have known there'd been other complaints. So I'm really curious what the backstory is on this. And, why are you giving out an employee's home address? There's no reason for one employee to know another employee's home address. Did they have any knowledge? I'm sure they will allege that, something was dangerous. You shouldn't have done that. You should have known. But this is similar to the shooting that we reported.
yeah. I think it's kind of hard to keep our rosters quiet. You have a firehouse, and I guess at least at one point they were assigned to the same firehouse. So
Right.
the roster's there. I think that's less of the issue. I think the bigger issue here is this kid had a propensity for violence. He had some sort of concerns, and we don't need to get into what those were, and I'm not even sure we fully understand what the allegations of them are. But he had a history, and the allegation is that the department didn't do enough to protect coworkers from him. And I think the angle that the news media took was, why is the victim now
Still
not
working
employed?
or fired,
Right?
and the assailant's still working. I forgot
Yeah.
that
I
part.
think that's the big question, and which leads me to believe. I mean, I know many of the folks from San Francisco. It's a very squared away department. They have their issues like any big city, but there's got to be more to this. It
Yeah.
just, as it's presented in the news media, it doesn't add up. So that leads me to believe there's got to be more to what's going on.
I'm sure. I'm sure. But crazy, crazy thing. But it again raises the question for our viewers of, if you know or should know or suspect that there could be a potential workplace violence issue, could there be liability for you if something happens on premises or off premises. Now, we've seen the on premises settlement of $2.3 million for the shooting, right? The captain. And the city clearly thought, okay, we knew city in that case, that was LA, right? Was
LA County. Yeah,
LA County. They knew in that case or that they had a reasonable chance of losing. So they settled, right, for the 2.3 or whatever. And then the estate settled. That was easier because the guy did it before he kills himself. But so it begs the question, and I would have taken a different stance. Should an employer be liable when something happens off duty, albeit on the firehouse or off the firehouse? Should they be liable for having to protect your employees from a co-employee? And yes, in the station, if you know about things and it's happening in the station, no question. Out of the station, wow, what could you possibly do? I go back to my proximate cause. What could you do other than tell the person, call the police? I had that as a fire chief. I had concerns about one of my employees, and I said, you need to call the police. I can't call the police on your behalf. It didn't happen here, but if something happened off work, you need to call the police. And I documented the heck out of it because that's what we should do. What more can we do? But this, if this results in liability now for off premises, even though they told him where he lived, maybe they knew, should have known, didn't know, who knows? But it's opening up employer liability.
It is, and it's important to understand it's not strict liability. So they're going to have to show, number one, that the city had a duty, and that the reasonably prudent chief, the reasonably prudent officers, the reasonably prudent fire department would have done something that the department failed to do. So it's not like it's strict liability for anything that happens. There's got to be some degree, but the 1% liable, 2% liable, 51% liable. I mean, it raises a lot of questions there.
And look, this shouldn't be a decision that's made when it arises. The procedure to know what to do should be in a policy, a workplace violence policy, whether you're under a federal or state requirement or not to have one. You need to have one. You need to educate your employees what to do in this and many other circumstances. This is one of the policies, if you've been paying attention, that Curt and I will be addressing in our must-have policy service at musthavepolicies.com, right? If you haven't caught that, go to musthavepolicies.com. But workplace violence is one of those things we will be addressing. And one of the reasons that Curt and I really are excited to do this policy program, where we send you model policies and videos every month, is because all these cases are showing you, hopefully, the need for policies that, a captain, a lieutenant should be saying, oh, a co-employee just came in to ask for a home address of another employee. What should I do? Well, the answer, as you always say, the point of policies is to prevent the conduct we don't want, right? To encourage the conduct we do want. And this would have done that had there been a policy, had there been adequate training, had the employees known and followed it. This maybe never would have happened.
Yeah.
So, okay, let's go to Oregon.
The workplace violence is a difficult issue. I have some friends and clients that have been sort of on the other end, where they made comments in jest that were taken by someone who wanted to get them for one reason or another. But they made a comment, for example, I'm going to come down there and punch you in the head, kind of joking, somebody that they've known for 20 years and jokingly on the phone, but that's on a recorded conversation. And the next thing you know, people are getting fired for workplace violence. So there's got to be some sanity there between someone who is legitimately a threat, and there's a threat assessment component to the policy that you've got to evaluate. Was it joking? Is this a one-time type of thing versus someone who's actually a direct threat?
Right. No question. Okay, let's go to Oregon. This is, look, the facts here are complicated. I'm going to summarize it to a couple lines because it's not really that complicated. But the point of this, before I go through it, that people should understand, when somebody makes a complaint, there's an immediate need, a desire of some people to retaliate in some way. You accuse me, you accuse the department, you're not loyal, whatever it is. You better make clear you never retaliate against anybody for any complaint. And there's a look back. The courts have said, 2 months, 4 months, 6 months, if something happens within the date of their complaint to them that looks retaliatory, up to 6 months, the courts will look back and say that could be close enough in time, proximate enough in time, where it was as a result. You get out a year or 2 years, and the courts are generally like, yeah, it's probably not related. But when something happens pretty soon after a complaint, or a series of things may happen within that time frame, you know, you're going to get a court's attention. So here in Oregon, we have a firefighter who's up for promotion to I think a deputy chief's, or, you know, a high-ranking position.
Yeah.
And he finds that another chief is making potentially, let's say, false statements, and about applying for a grant. And he's trying to beef up the application, I believe the allegation would be, by saying we have worse statistics than we really do. And it's a safer grant, which many of you know is to one of the purposes is to hire career firefighters or paid firefighters. And, you know, the federal government pays a declining amount over 5 years, but you need to prove that you need the firefighters. So he reports it. He believed that the chief was misrepresenting the number of non-emergency transfers that they were taking, right? Beefing up the statistics to make need look more important for the application. And then all of a sudden he alleges the retaliation starts. All right. And this is, let's just be very generic about it. This is a normal retaliation. Denials of promotion, potentially investigations of, oh, you did this to someone else, so we're now going to investigate, which I'll talk about in a minute. Right. It's the litany of normal things, normal ways people come after you. And frankly, as soon as I saw the headlines, I'll tell you why I'm saying this. I could have said, okay, I'll bet here's what they did. Treated him bad at work, denied a promotion, blamed things on him, denied him sick leave or something else, and all tried to make it look like it has nothing to do with his complaints, because that's always what happens. But here's the problem. If I know it, judges know it, right? Yes, you and I, Curt, see these all the time, but these are basic retaliatory steps that people will claim they suffered or do actually suffer, and you've got to be careful. Here it went one step further, which is going to be a little harder to prove. They go out and get an investigator, I think an independent investigator, if I can use that term, and he claims that even the investigation was skewed. I will tell you, kudos in the sense whoever chose to get a private and independent investigator, because that's going to help. If you do your own internal investigation, right, as you've commented many times, that does really nothing for you to protect yourself against retaliation or bias issues. But you use an independent investigator, you know, you're not paying them to come up with, hey, I want you to, you know, really nail this guy. You're presumably paying them for independence. Hopefully.
Sometimes investigators will, though. That's a problem
Sure.
with lawyers, Brad. And that's when it comes to lawyers, you got to be very careful of going outside and hiring a lawyer, because a lawyer is used to zealously representing their client, and they'll pursue the person that the client tells them to pursue with the same zealousness that they normally represent the client with. And that's not what you want in terms of an investigation.
And I take a more basic approach to it. I say, if you keep hiring the same investigator who knows that they're going to get more work from you, they certainly don't want to piss you off.
Right.
So, you know, I think there is that problem. But in any event, that can be solved in an engagement letter saying we're not paying you for the results. We don't care what you find. We're paying you to conduct a fair, independent investigation without regard to any loyalty to us.
Without any wink. No winking.
No winking, right.
No winking. Yeah.
Anyway, so that's it. And look, at some point, you start seeing these repetitive patterns, which I know you're even studying, right? Repetitive patterns, but you start seeing basic employee or employer repetitive patterns, and the courts get used to that. They're like, oh yeah, this happened here. And yeah, you're acting just like a bunch of other guilty people. So you really got to tell people, you got to go a long way to say no retaliation. And here's what I'm saying. You've got to predict that this is how the employee, right or wrong, is going to react. Right? When you fire somebody who doesn't ever think they did anything wrong, you better have good documentation. When you have a probationary firefighter who's saying, oh, I'm being treated differently, you better have a good reason why you're terminating them. It better be in, you know, on this date, they did this. We've seen good and bad examples. You better predict it. So my lesson to everybody, our lesson to everybody is, get used to these cases by seeing an employee's reaction to what you did and start planning for that reaction, right? You know it's coming. Most people today aren't going away quietly. So be prepared to say, here's all the things you did, right, that we are coming after you for, and has nothing to do with anything you did, reporting, whatever.
I do want to point out one thing, and I don't know any of these people, but there's also a second fact pattern here where you have a problem employee who wants to tee up a retaliation claim. They know they're in trouble. They've been doing things, they've been pissing people off for whatever reason, and they're going to tee up a retaliation claim by finding something to complain about. And I think, who knows what's actually in play in this particular case, but that's another fact pattern that we've got to look for when you have a person with a history and all of a sudden they decide to complain about something. Now, maybe what he's complaining about is legitimate here, that it could be, but he certainly appears to have teed up a retaliation claim. How long can it go? Some retaliation claims, I think your advice there is sound. 2 months, 3 months, 6 months. I think that's sound. Okay. If you're going to go longer than that, you're going to have to prove. You can still go a year or 2 years, but you're going to need some sort of proof that that's why. An email, another witness who heard the chief say, "We're going to get Pinsky, we're going to get Verone," and you're going to need something more than the implication. The implication is based on time. The inference is based on time. But if you're going to go a year or longer than that, you're going to have some sort of other evidence besides just that, the time connection.
Right. I mean, I have a case now. I don't want to say too much about it, but it makes the point. I have clients who reported something to the state on, let's call, day one, and literally within 60 days, they're terminated for something that happens on a call.
Imagine
Go
that.
figure.
How that happens. It's funny
right?
how that happens. Yeah.
And you've got no disciplinary history. You've got not, but all of a sudden, right? I had one come in the other day. I'll be even more vague. Something happens, and two people get into an argument, right, in a public meeting, and the very next day there's a call that doesn't go perfectly, and one of those people forwards it to the state saying this person should lose their paramedic certification. And, it's the next day. Now, you could argue coincidence, or you could argue, right? But it starts leading to this. Was it retaliation? Was it not? You better be real careful. But on the other hand, it's not a free ticket for the employee to say, I'm going to act any way I want because I'm just going to sue you if you do anything about it.
Right. And I think there are people out there that will do that. There are people out there that will just kind of go through their career teeing up various whistleblower retaliation claims in case something happens. And these are usually your toxic employee, whatever you want to call them, your difficult, high conflict employees.
Yep. And so my one piece of advice, I said, if I'm going to sum this up in a word, my one piece of advice, when you discipline somebody, you better have a good write-up. Right? Not we'll figure it out later, because you're not going to remember anything a year, 2 years, 5 years later when this goes to court or depositions. You better have everything in writing, why you did something, what they did, that you talked to them about it, whatever it is, because darn well they have something everything in writing against you, and you better be able to refute it with, well, what about all these counseling things? And that's why I don't like verbal reprimands that don't have some documentation, which kind of makes a written reprimand.
You got to have document. Yeah, you got to have
documentation. Right. So, but a lot of people are like, oh, it's verbal, we don't write anything down. Yeah, you better make a counseling note that you did or it didn't happen, right? Okay, so this next one, we're going to go to Delaware, where a conviction of a chief has been upheld, partially upheld.
He filed a motion for JNOV, and
judgment notwithstanding the verdict, so everybody understands.
So he basically wanted the judge who heard the case to say that the jury did not have enough evidence to find me guilty.
Right. And he does that on the basis of the statute's term that they convicted me on is vague. And the statute, this is a legal argument, the statute is there void, meaning it should be taken off the books because the terms it uses are vague. And the court goes through what's called the void for vagueness analysis. And it's basically, does the language in a statute give a person of ordinary intelligence fair notice that the behavior they're trying to outlaw is forbidden, or whether it encourages kind of an arbitrary outcome that you don't know what it means. So if something's criminal or prohibited, it's got to be clear that that's criminal or prohibited. It can't be vague. But here, the statute talked about whether this person was a person of trust. So what happens is, this is sexual assault, and it says when somebody basically says that when somebody who is a person of trust coerces, influences, uses that trust to violate somebody's, sexual privacy, etc., assaults them. And in this case was, I think, a training chief or deputy chief who is a person in trust over a junior firefighter, a young, I think, 15-year-old firefighter. And the question is that a person in trust? Of course it is. Nobody in the right mind would say it's not. In my opinion, the judge agrees the statute is not vague. This definition, whether it's defined or not,
but I think you got a point. And I'm not saying he should get off. I'm not saying, don't misunderstand what I'm saying here. He is a deputy chief in Fire Department A. She is a junior firefighter in Fire Department B. And I think his argument, if I understand it correctly, is I'm not in a position of trust over her. I'm a deputy chief in my department. She is a junior firefighter in a different fire department. Therefore, under this statute, the statute may be fine as written if I was the chief of her department or a chief in her department, but I'm not. And applying it to me in this situation would be vague.
Yeah, and to even get in a little more in the weeds on that, his argument was, I may be a person of trust, as you're saying, as a firefighter, as a chief, but right now with her, the problem I see with this is like any firefighter, any police officer saying, hey, I'm, a fire chief over here, you can trust me. I'm a police officer, generally, you can trust me. And it's the person's public position. It's not like saying, oh, I'm a mayor of a village and trust me, right? You're there as a first responder where people are in that position of trust. And I think just wearing the badge, wearing the uniform, having the title is enough for anybody, whether you supervise them or not. It was a creative argument, but it would ignore the truth that we try to create a trusting relationship. For example, with kids, we put on turnout gear and do this crawling around. And hey, in our department, we always had people come touch our turnout gear, touch our helmet. See, it's not scary. Look, we're in a mask, but here we are under the mask. You can trust us. We're trying to create trust for the position, not for the person, and using your position to lure people in, as you have a number of cases on where they lure people in, or lure people to a park, or lure people to a parking lot, or whatever. To me, it doesn't matter whether you supervise that person or not. And I think that state's legislature recognized when they wrote the law, that was what they're trying to prohibit.
Yeah. I wonder if the prosecutor actually considered that when deciding what charges, because they should have just charged him with statutory rape. I think that would have been enough, but they wanted to add those things that enhance the charges,
right?
Charge enhancements to characterize them as a person of trust. But I would have thought just a basic statutory rape would have been enough. So.
But to me, it's just like, and I'm betting this is where it comes from, when you're a teacher in the school. I may not be your teacher, absolutely, but I am a teacher in the school.
Right. But now what if you're a teacher in school A, in community A, and the person's in school B, or
right?
I don't know. I think that's the issue, but we'll see if it goes up on appeal. I guess when you don't have facts, when you can't argue the facts, you argue the law, right? And when you can't argue the law, you argue the facts. So they're arguing the law here. So,
and if you don't have anything else, take the judge out to dinner.
Yeah.
All right, if maybe you could do, because this is long and complicated, right? Massachusetts Civil Service, which is now upheld the discipline of a Springfield firefighter. I'm going to be in Springfield soon.
Yeah, and again, I don't know. I don't know what their internal disciplinary system looks like in Springfield, so I'm just going to speak in generalities here. But we've got a lieutenant who had he was apparently the union president, or he was a union rep. And back in 2018, there was a chief who was being investigated, and as I guess in his capacity as the union president, he tried to talk to a witness, another lieutenant, and encourage that witness not to testify, which, by the way, is a criminal offense.
Yeah, don't ever do that.
You cannot tamper with witnesses, whether you're a union rep, you can't do that. That's, I guess, I don't know, he probably didn't get the memo, but bottom line is you do not try to change somebody's testimony. That is, you're fortunate that you didn't get charged criminally, okay? So bottom line is he tries to get the lieutenant to not testify against the chief, and he ends up getting disciplined. So that's 2018. Fast forward now to 2021, and the lieutenant, I guess we have to use their names because otherwise it'll be too confusing.
Right,
so the lieutenant who is the union rep is Lieutenant Blake. The lieutenant who was going to be the witness is Lieutenant Jones. Okay, so Lieutenant Blake tells Lieutenant Jones, don't testify. And Lieutenant Blake ends up getting disciplined. Got 2 days off. He's I think pretty fortunate that it didn't get any worse than that. Right. So now fast forward to 2021, Lieutenant Jones is at his house. Somebody's burning across the street or in the neighborhood. He calls the dispatcher, but he doesn't. Apparently, it's not a very good neighborhood. There's some problems in the neighborhood, and he doesn't want to identify himself as being a fire lieutenant. But he calls 911, says there's somebody burning. The dispatcher starts the inquisition. Who are you? What's your phone? All that. And he says, I don't want to give it. And then the dispatcher apparently says something that, well, if you don't tell us, we're not going to send the trucks. And so he gets actually, he hangs up when they ask his name, and then they call him back. So, yeah, so they ask him who, he gave them his address, gave him the address of the fire, and they said, what's your name? He hung up. So the dispatcher now calls him back, and the dispatcher starts saying, well, we need to know, and blah, blah, blah. And he says, well, fine, then don't send anybody, let him burn, I don't care. And he again hangs up, okay? So he's off duty, and it is what it is. So now who gets dispatched? Lieutenant Blake is on the engine that gets dispatched to this illegal burning call. He catches wind of, he recognizes the address, or somehow is able to determine that it came from Lieutenant Jones's house, contacts the dispatcher confirms that the caller was not cooperative, didn't provide enough information, and Lieutenant Blake now takes it upon himself to launch an investigation, and then he reports it to his chief, who incidentally happens to be Chief Savage, who was the person who was potentially Lieutenant Jones was going to testify against. So now that's what happens in small towns, I guess. But Springfield's not that small a town.
It's not. It is not a small town.
So, but at any rate, somehow Lieutenant Jones does some sort of investigation and prefers charges against Lieutenant Jones. Lieutenant Blake prefers charges against Lieutenant Jones, which that should never happen. Lieutenants should not be preferring charges against anybody. They should be reporting that possible misconduct happened, but you should not be issuing charges against someone. Okay.
I don't even know how that would be allowed. A complaint's one thing.
A complaint is one thing, absolutely. An allegation is one thing, right? A complaint is essentially an allegation, but you do not issue charges, okay? Right. But apparently, and the rule book in Providence went back. I had copies of the rule books going back into the 1800s, and they had very general language that said when an officer becomes aware of misconduct, they are to investigate, not report it. They're to invest. Yeah, I know.
That's a horrible rule.
Oh, I'm telling you. So, but many fire departments, especially ones that have a history of having rules and regulations that go back at least 2 centuries now, back into the 1800s, may find that they have rules that still authorize that. And you could conceivably have 3 captains investigating the same firefighter for the same thing. And because everybody can create their own investigation, it's crazy. It's crazy. So at the end of the day now, Lieutenant Jones, once he became aware that he was facing charges now, filed a harassment complaint with the department. They ended up having
100% predictable.
person. Yeah, they had an HR person come in and do the investigation and concluded that Lieutenant Jones was indeed Lieutenant Blake was indeed harassing and retaliating against Lieutenant Jones based on the previous thing. And now he ended up getting 4 days off without pay. And the case that we've got a copy of in the blog is basically the Massachusetts Civil Service Commission agreeing that the city was justified in disciplining Lieutenant Blake. So it's to me, it's an interesting case, and it talks about the importance. We're getting back to policies, and this is not a marketing for our policy thing. I don't want anybody to think that, but it goes back to the importance of having a discipline policy
and an investigation policy.
It's got to spell this all out.
Yeah.
So,
you know, you find the same thing. Departments are so good at not so good. They focus more on discipline. They forget the whole charging and investigation portion, and they just all of a sudden the charge becomes the guilt.
We only investigate people who are guilty. If people are not guilty, we don't investigate them. So the job of the investigators is to get the guilty person and prove the case. You know, it's easy to do it that way. It's right. And hopefully you realize I'm being, sarcastic here, because you can't do that. You have to investigate with an open mind. If you think you only investigate people who are guilty, guess what? You're in the wrong mindset to do an investigation.
Right. And the same with whether you believe or not the accuser, right? Mm-hmm. Yes, accusers who keep accusing maybe lose their credibility, or accusers maybe who are being disciplined for something else, it seems retaliatory, maybe they lose their credibility, but you still have to investigate. You can't pick and choose, is your point. You can't pick and choose what you investigate. You investigate everything. That's the end of it.
Because what happens is you don't investigate the people you like, because you don't believe the people you like could have done something wrong. And even if they did, you don't want to see anything bad happen to them.
Right. And on the same token,
so then we have a group of people that we don't investigate, who basically can do whatever they want. They're the fair-haired boys. They can, they're untouchable.
Yep.
Who do we end up investigating then? The people we don't like.
Right. Right.
And then you get bias and along all sorts of different protected class lines, and just people you don't like. And we're happy to investigate them. And now we have a dysfunctional system that nobody trusts because they've seen it work.
Which kills morale, which leads to abuses, which leads to people leaving, all of these things. You need fair and good discipline. I remember when I became chief, a good friend of mine who was a paid lieutenant at my department I said, if there's one thing you could change, what would it be other than response times? And he said, discipline. He said, we have no sense of discipline. That's when I was coming into chief. I said, I want to know, right? And his comment was, we have no discipline and it's bad for everything. And it is. People don't, you're his friend, you won't be disciplined, or you're his family member, you won't be disciplined, which, by the way, in small volunteer departments is a big deal. I face all the time. Hatfield McCoy's, that's his son. The chief will never investigate. You got to have a fair investigation disciplinary process.
If we do not have good discipline in the department, put it this way, if we have good discipline in the department, we should rarely have to punish.
Right.
We should rarely have to punish, because we find out about problems early and we say, look, you can't be doing that. I'm giving you verbal, don't let it happen again. And that's what we should be doing. But unfortunately, if we like people, we tend to kind of look the other way at stuff, and they get the message that it's okay for them to do it. And we just pursue the people that we don't like, and we don't treat the people we don't like fair. And we're not really doing the people we do like a service, because they're going to keep doing what they're doing. Eventually, they're going to get themselves in so much trouble that, and that's the ones that you have these you end up with these big scandals involving dozens of firefighters. And you say, how did this happen? That's a big time department. How did this happen?
Right.
Well, that's exactly how it happened.
And I'll tell you, in the last year, I've had 3 threatened lawsuits, right? And I do this too. The lawyer will send a letter and say, here's the reasons we're going to sue you. Here's a potential complaint or lawsuit, which we intend to file unless we can work something out. So my clients, 3 separate clients, have received 3 of those from different employees. Now, kudos to the each of those clients, because in each of those 3 cases, it never got to a lawsuit. I was able to spend about 10 hours of, their paid time, or some case 30, 40, 50 hours, but they provided me with all the past discipline, investigations, write-ups, counseling memos, suspension note, whatever. And I was able to take that and say, look, here's what we have against your client. Here's what you have against us. And here's the history why we got rid of somebody. Have nothing to do with this. And in all 3 cases, not because I'm a brilliant lawyer, but in all 3 cases, they never pursued it. They've never, and these would have gone on for years, right? And so what you have to convince the other lawyer of, and clients, you need to put us, the attorneys, in that position. You need to help us help you by saying to the other attorney, this is what you're going to be up against. We're showing you now. We've got pages upon pages showing your employee, your client, was a horrible employee. And I had 1 or 2 in the last couple of years who had nothing. And I'm like, we should just settle this now, because it's he said, she said. I got nothing. You said they did all these things wrong, but there's no record. Oh, well, there's an email. Oh, come on. Right? I mean, that's not how it works. So this stuff matters in real life. It matters in real life. Put your attorney in a position to help you win or prevent the case. No. And we don't talk about on here, because they don't wind up in the news, of all the cases we're able to prevent. They don't. You see everything gone wrong, so to speak, or sometimes gone right, right? But normally, a good lawyer can get this stuff not dismissed, that prevent even the lawsuit.
It doesn't happen when you do things right. It's just like a Mayday. If you're doing things and things are going along well, we don't have Maydays. We don't have line of duty deaths. Right. So, okay,
last one. I like this. I wish it didn't get dismissed, because we're going to talk about the dismissal. The facts would have been so good, but we talked about this before, and even during COVID, there was a lot of this. But we have candidates, probationary employees who were, I'm guessing they're at the academy, but they're firefighter trainees. They're required to quarantine, during COVID, and they said they wanted to be paid for that time. I wanted the results of that, because I think they should have been required.
Here's the thing, and this is an FLSA overtime lawsuit. There's a specific provision in the FLSA that they call it the Fire Academy or Police Academy exception. If you are sent to an academy and you are required to remain in residence there, your time is not compensable other than the time you're actually in class. Could not possibly be clearer. It doesn't matter if you're sent to, I've got friends in South Carolina. The South Carolina Fire Academy has a hotel on campus. You could go to the National Fire Academy. If you're required to be on campus, you are not required to be paid for the time that you are not required to be in class.
But the rub here, I would argue, if I was them, but they never got the chance, and that's kind of the point of this. Right. And well, let me jump to the end. In short, the judge concluded you blew the time limit. You couldn't file. You filed too late. That's the end of it.
Yeah, which I think is kind of crazy. I
don't understand how the lawyer blew this, but lawyers now pick up the phone, call their insurance company, and say, well, I knew about this for a long time. I screwed it up. Now, I'm not saying this lawyer did or didn't screw it up. They may have gotten the call after the deadline. You don't know when the lawyer was hired, so I'm not saying that. But in either event, it's kicked out for statute of limitations. I'll talk about that in a minute. But the rub here that I really found interesting is the FLSA's reason, I presume, for saying, listen, when you're at academy, it's like being home. It's your residence, right? The difference here is we're confining you to your room, and your free time is no longer your own. We're basically incarcerating you, which is how I would have looked at it. And I would have said that's not I would have argued, if I was them, maybe they did, that this was not the FLSA's reason, because you can walk around campus, you can leave. The fact that you have to sleep there or study there, because I know there's been cases where you said, well, you mandate that we study X hours, and the court said no.
Study time can be when it's mandated, but hopefully... Right. People that are running academies today know you can't say you need to put in 4 hours of study time tonight.
Right. Right. But here they've confined them to the room. I used to say during COVID, during all our radio shows, you've incarcerated them. And so that's the question here.
Well,
it's never going to get answered.
I know our state police in Rhode Island, state police have a sleep-in academy. And one of the things that they historically have done, and I think I started in Providence in 1979 before the FLSA applied to municipalities. FLSA went into effect in 85 for us, but at the fire academy, when we slept in, they would tip the bell at night and get you up. So yeah,
Oh,
now what they
that should
do,
be compensable.
well, it would be today. It would be today. They have in Providence, they dispense with it, but at the state police academy, they get them up at 2 o'clock, like the Marines. They get them up at 2 o'clock in the morning and go for a mile run, and then go back to bed, and then get you up at 6 o'clock for calisthenics and all that. So today, they have to pay for that time. But
Right.
you can be in residence at the police academy now, and once class is over, to the extent that you're free to do what you want to do. If you want to watch TV, you watch TV. You want to read, you read. And I think you raise a good point. If you're confined to your hotel room now, I mean, maybe you can read, maybe you can watch TV, but you can't socialize. Maybe you can call home, go on the internet, but you are somewhat limited. So that may change it, change the dynamics. But I think if
Well,
you
we'll never know. I'll never know.
right, we will never know, but at least for now. But it's an interesting issue. But there is that fire academy exception, and I certainly don't want fire departments out there that have academies to say, oh my God, we're going to have to pay them 24/7 if we keep them in residence.
Right.
There
You'd be
is
paying time and a half for so many hours. It'd be ridiculous.
Yeah.
So, okay. Well, that's the case for this week. I do want to say on that statute of limitations time, though, is, people got to be real careful about that. Statute of limitations mattered. And I'm hoping to bring to you, it's down in Long Island, a case where it's been going on for 4 years, arguing back and forth, not filed. They finally file suit, and I'm being very generic. They finally file suit, and we said, statute of limitations. You made a decision back here, and you just keep trying to re-argue it, and you're arguing about it, but the decision's made way back here, statute of limitations. And I keep laughing, like, I can't believe we're arguing about things for 3 or 4 years. It's going to be such a great case to bring to make clear when an agency makes a decision, this is our final decision. Just because you keep telling me I should reconsider it doesn't extend your time to file. And that's a very common win that I often find when, hey, if they want to think they're extending the time to file a lawsuit just because they keep sending us please reconsider, or did you think about this challenge? That doesn't cause anything. So, for example, a municipality renders a final decision and says, this is our decision. The fact that starts a deadline for how long you can appeal it, 4 months, a year, whatever it is. You keep writing to them or showing up at a public meeting and complaining about it or asking them to reconsider, doesn't extend the time. And then the lawyer gets it, be like, what do you want me to do? So I'm hoping we get the decision, but it's the same type of thing on a statute of limitations. You better not wait. Your time usually starts on an administrative appeal when a decision is made. For everything else, it's when were you harmed, or when should you have known you were harmed? People mess this up. So you don't want to put yourself in the position where you're missing a deadline to file, just like here. I would have loved to see it. But hopefully we make you smarter plaintiffs, smarter defendants, and smarter people generally. That's it.
All right. Well, that's going to do it for another edition of Fire Law Roundup. Brad, thank you again. We'll see you again next week.
Have a great one.